Abby Pendleton, and this is my colleague Jessica Gustafson. We're both attorneys with the Health Law Partners, and although we practice in a wide variety of areas of healthcare law, Jessica and I do devote a substantial portion of our practice to assisting providers and suppliers with regard to Medicare audits and other third-party payer audits, as well as in the area of compliance. And lately, a lot of the focus has been on the Medicare Recovery Audit Contractor Program.
Recently, we have received numerous questions from physicians and other healthcare providers about the Medicare Recovery Audit Contractor, or the RAC program, as it is expanding nationwide beginning this year. Abby and I have significant experience in the RAC program. We have represented physicians and hospitals that were subject to recovery audit contractor audits and unfavorable claim determinations in the demonstration program. We appealed hundreds of these claim denials and have really learned a lot from our experience representing these providers. We continue to represent hospitals in the appeals process as their claims proceed up through the various stages of appeal.
For those of you that are not that familiar with the Medicare RAC program, CMS has entered into contracts and put a bid out to enter into contracts with various vendors who are contracted to go out and seek overpayments for the Medicare program. And these contractors are paid on a contingency fee basis. And the program became nationwide and permanent pursuant to legislation passed by Congress. And as of March, we were at about 20 states. Next year, all 50 states will be impacted by the RAC program. To be prepared is just crucial in this process. And it depends on the size of your organization, how prepared and what type of mechanism that you're going to put in place in order to assist your organization with a program. But for those larger organizations, you really need to assemble a team that's going to understand the areas of scrutiny. Where are the Medicare RACs going to scrutinize what types of claims? And for those of you that are hospitals and health systems out there, you understand, and you've probably read a lot, that for sure they're going to be looking at the one-day stays. If experience teaches us anything, it's going to be one-day stays. It's going to be inpatient rehab facility claims. It's going to be certain DRG coding. So those areas you can now start to look at and make sure that you implement measures to help you if you do get subject to the RAC program. Although you cannot stop or prevent a RAC audit, or for that matter any third-party payer audit, you can implement measures now to assist and help better navigate if you do get hit with a RAC audit or another payer audit. Having those systems in place include having somebody or a team of individuals that are responsible for actually identifying when a claim denial occurs, keeping track of that. There are software programs for some of the larger organizations, or even Excel spreadsheets where you're tracking denials. And then there's also a component where you need to be aware of what are the areas that are potential that are going to be under scrutiny. And then you also have the appeals process.
It's important to understand that all of these RAC claim denials can be appealed through the standard Medicare appeals process. This process changed in 2005. It's a 5-stage appeals process, beginning with a request for redetermination, which is filed to the intermediary or carrier, which will soon be the MACs after that transition has taken place. The second stage of appeal is to a qualified independent contractor. That's called the reconsideration stage. The third stage of appeal is the administrative law judge hearing stage. The fourth level of appeal is the Medicare Appeals Council stage. And finally, you have the option to go to federal district court if you do not receive relief at the underlying 4 levels of appeal. There are several ways to appeal RAC or other Medicare claim denial. One of these ways is just simply attacking the appeal on its merits, going back to Medicare and explaining why the RAC decision was wrong and why you are entitled to payment for the services. This will likely involve drafting a position statement or engaging a qualified expert. For example, during the RAC demonstration program, hospitals received short stay claim denials, and to appeal these claim denials, one effective method is to engage a physician to testify why an inpatient admission for these short stays is appropriate rather than a different level of care, such as just an outpatient claim or even outpatient observation. As a matter of practicality, it may not be possible to get every admitting physician to get on board and participate in the hearings. However, it may be possible, and has been shown to be possible in our experience, to contract with, for example, a case management physician advisor or another physician who can take a look at the file and review the case and see whether that physician agrees that an inpatient admission is appropriate. Just having the physician testimony is helpful in these types of cases. So one effective appeal strategy is simply arguing the merits of the claim. There are also legal defenses that can be employed that have been successful in overturning unfavorable claim determinations. For example, provider without fault. Another thing to keep in mind is that recovery audit contractors are authorized during the permanent program to use statistical extrapolation. That means the RACs can request to receive just a small sample of your records, review those records, take their findings, and extrapolate those findings to your entire patient population. One method that can be used is to challenge the extrapolation using expert testimony, for example. So these are all things to keep in mind as you prepare your appeal of a RAC or other Medicare claim denial.
I think in summary, we expect to see an increase in auditing activity by Medicare through the RAC program as well as through other Medicare contractors. We expect to see that increase also in the commercial arena. And for providers, we would recommend that you really take a careful look at your compliance plans, really looking at your areas of weakness. Every provider has issues with documentation, and try to enhance and facilitate your documentation so in the event that you are faced with a Medicare or other third-party payer audit, you will do much better on the appeals process when you've taken those compliance measures on the front end. If you have any questions concerning RAC audits or any Medicare audit or just in the field of healthcare law, you can feel free to contact one of the Health Law Partners attorneys. Our information is available on our website. Thank you.